Hi, I'm DeAnn Chase, founder of Chase Law Group. I'm here today with Scott Liner, our employment attorney. Hi, Scott.
Hi, great to be here.
Thanks for being here. I really appreciate that we can have these conversations in order to guide employers through a lot of the scenarios that we see on a regular basis, right? And so what we're talking about today is when an employer receives a request for employment records, but maybe talk about what sort of request triggers something for an employer, and what does that look like?
Okay, absolutely. So what we're talking about here is whether an employee who's currently employed by the employer or is a former employee, and whether they get a communication from the employee themselves, or where I mostly see it is from an attorney representing the employee. And employers have certain obligations under applicable statutes of what to do. So there's multiple types of statutes and records that are involved with record requests. Typically, the type of request we'll see is someone wants to see a copy of their personnel file. So hopefully, most employers keep a personnel file. The personnel file, what is in it? There's no hard and fast rule. Typically includes someone's job application, their hiring documents like their I-9, and other documents relating to their hire. It may include a performance review. If there was some disciplinary issue, that might be in there. As it relates to like private health information, that should be kept kind of in a separate private file, separate from the personnel file. So these are the type of things that should be in there. Not every email communication, or even if like an employer is telling somebody, hey, you need to kind of improve on this, it doesn't have to be in the personnel file. The second type, and by the way, that type of request, first of all, by an employee or by an attorney representing them, must be in writing. But if the employee asks verbally, if they're there, hey, I want to see a copy of my personnel file, you of course will provide it. Just ask if they can send an email, because the request is supposed to be in writing. And then the employer, whether it's from a current employee or a former employee, or from an attorney representing the current and former employee, an employer has 30 days to provide those documents. Okay?
30 days from the request.
Exactly. The second type of request that I see and typically comes up is a request for payroll records. Payroll records under Labor Code Section 226 requires that the employer produce pay stubs, copies of pay stubs that, yes, the employee already received, but you're required to produce those, as well as their time records. So this allows them to see if they were paid all the money that they are owed for the work that they perform. Now, when it's your own employee and they're still working for you, this can be done very easily. Unless it's a problematic employee or one who you think may be filing a lawsuit, then you may want to talk to a lawyer about this before you produce something, just so you make sure and understand what the issues are and how to present it. But ultimately, it doesn't matter. You've got to produce these records. If it's a letter from an employer, it's usually going to be in a letter format where they introduce themselves in the letter. It's going to be sent to the employer. Correct, yeah. It's going to be a letter from the attorney. It's going to be sent to the employer, because they don't know if you have a lawyer or not, one way or the other. And it's going to indicate that they represent the employee and that the type of records that they're requesting, and typically the statutes under which the request is being made. And oftentimes, that it has an authorization form signed by the employee that's authorizing that the records be released to the employer. By the employer to the employee. The third type of record request we see is a Labor Code Section 435 request. This includes records that are signed by the employee, but not every record at the company the employee signed. It's the most substantial and substantive things, like if there's an arbitration agreement, if they sign an employee handbook acknowledgement form, if they have a contract, those type of more significant documents, those also would need to be produced as well, along with the personnel file.
So aren't those documents automatically included in the personnel file?
Well, you'd like to think so, but not always, right? And again, they don't have to be. So it's kind of a catch-all request, but when they're made, because they may not be in the personnel file. There's no requirement of what has to be in a personnel file. It's understood what should be in there, but there's nothing specific. There's no law that says this has to be in a personnel file.
Got it. So when an employer receives a request, either from an employee or from an attorney representing the employee, that has to be in writing, then the request will usually let them know what records are being requested, and the employer is obligated to produce those records within a certain time frame.
Correct. And so with personnel file records, it's within 30 days. For payroll records, it's 21 days. And potentially the employer, as it relates to personnel file and both of these, they can, if they're a current employee, they can be required to come to or stay in. They don't get to take the records from their personnel file and take them home with them. Okay.
Oh, okay.
If the employer wants to make copies of it and provide it to the employee, they can charge the employee the copying costs. I don't recommend it. It's not probably a lot of money, but if it's a thick, file, then maybe so. But you can make them review the file there at the office. One thing that I recommend is when you get these types of requests, particularly from a lawyer, but also when it's from the employee themselves, is to consult with an attorney. Among other things, there always are questions about, is this responsive? Is this particular document responsive? Is it part of the personnel file? Do we have to produce it? And if you don't want to produce it, if you don't have to produce it, maybe it's something that you should produce, even though it's not in the personnel file. It also allows an attorney to have an opportunity to interact with the lawyer if it's a letter from the lawyer, and it gives the lawyer for the company an opportunity to communicate with the employee's attorney, to present important facts or circumstances, because usually these letters are sent by attorneys for employees because the employee went to the attorney and thinks they have a claim or has some issue, and the attorney doesn't know. And so they want to get a copy of these records to see what's what and if there are any issues. So if there is anything, or even if there's problems with the employee's performance, or if they were let go for performance issues, it gives the employer an opportunity through the lawyer to both produce the records as well as to make the argument in the case as to why the employee was fired before a lawsuit is filed. So again, anytime you get these type of requests, whether it's from an employee working for the company or a former employee or from an attorney, consult with an experienced employment attorney just to make sure that the right records are provided and that there is some decisions that might be made strategy-wise as to what and why you might be producing certain additional documents or certain additional arguments that can help the employer situation.
Great. Well, thank you for that. And as we know, I mean, it's so important to consult with an attorney and an experienced employment lawyer. And I say early and often, right? But as soon as that request comes in, even if it's just literally the employee during the workday saying, "Hey, can I get a copy of my personnel file?" The employer just needs to immediately be aware that they have to very carefully provide specific documents and in order to lay the foundation for defense if in fact that this request is going to lead to a later lawsuit. So thank you, Scott. Here at Chase Law Group, we are so happy to have you as part of our team. And anyone who is interested in either maybe you as an employer have already received that request and you're sitting there going, what do I do? But feel free to reach out to us here at Chase Law Group, and we can set up a time for you to speak with Scott about your issues. You can reach out to us through our website or just send us a direct message. So thank you, Scott.
Great to be here. Thanks for having me.